seated.
Come to order, please. Oh, that's all right.
Please be seated, ladies and gentlemen. All right, solicitor? Yes, sir.
The state would call Mr. Robert Ridgway to the stand.
Come on forward, Mr. Ridgway, to be sworn, sir.
Place your left hand on the Bible, raise your right hand, state your name, please.
Robert Ridgway.
You solemnly swear or affirm your testimony to the court to be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you, sir. Have a seat with you, please. Please state your full name and spell your last name for the record.
Robert L. Ridgway and R-I-D-G-E-W-A-Y.
Mr. Ridgway, where do you live, sir?
Presently,
Now.
Summerton, South Carolina. I have a Summerton address. I live down at the lake.
And Summerton is in Clarendon County?
Yes, sir.
And when were you born, sir, if you don't mind me asking?
February 27, 1931.
All right, sir. And between, were you born in Clarendon County?
No, sir. I was born in Barnwell County.
All right, sir. And tell us what your father did for the better part of his life.
Railroad,
All right. What railroad line did he work for?
Atlantic Coast Line.
All right, sir. And did you ever have the occasion growing up to live in Alcaloo, South Carolina?
Yes, I did.
All right. Can you give us a time period? For example, were you in Alcaloo in 1944?
Yes, sir.
All right. And based on your age, you were born in 31?
Yes, sir.
All right. And so in 1944, you would have been about 14?
13. 13, yes.
Did you follow your father into the railroad business?
Yes, I did.
And tell the judge a little bit about your experience. When did you become a railroad man?
March the 3rd, 1950.
And how many years did you serve as a railroad engineer or worker or transport worker?
43 and a half years.
And did most of that time, were you working for the Atlantic Coastline Railroad?
I worked with Atlantic Coast Line and Seaboard Coast Line, which was submerged line,
Yes, sir.
until from 1950 until 1976.
Yes, sir.
And in March of 76, I went over to Amtrak,
All right. And how many years did you work for Amtrak?
17 and a half.
And then you retired?
I retired, yes.
All right, sir. If somebody had come to you in 1944 and said that they found a piece of iron rod about 12 to 15 inches long, kind of round in shape, what would you say that, as a railroad man, would that pop something into your head?
Well, not necessarily, unless I were to see it, then maybe I could identify it as.
All right. Let me ask you this. To the best of your recollection, in 1944, were the railroads using spikes to tie down their tracks?
Yes, sir.
Were any of those spikes 12 to 15 inches long?
Oh, no, sir.
How long would they have been during that time period?
Probably 4.5 inches. Could have possibly been 5.
All right. If we had a piece of metal that was associated with railroads and tracks and things like that, that was in the neighborhood of 12 to 15 inches long, heavy, made out of iron, what would that have been associated with as far as you're concerned?
I would have to see it.
All right, sir. Let me show you an object. I'm going to put it on the screen right next to you. Can you see this picture? It appears to be an iron laying on some bricks. Can you see that? Is it on your screen?
No, sir.
All right. Maybe we have a moment to cut your screen on.
That's mine. You might have to. Thank you. Got it. You're not talking which way we're going. No.
That's it.
It is, okay, yeah. What you say.
That,
Can you see that pin, sir?
yes, sir.
Does that look like a railroad pin to you?
It has appearance of a drift pin.
All right, sir, and it's called a drift pin?
That was the common term that was used. Actually, it would be technically it would be call the name of it, draft pin, I think to be used a great term.
All right, sir.
It was used in connection with the couplings of the old or antique rail equipment.
All right, and when you say coupling, you mean joining one railroad car to another car?
Yes, sir.
And these pins were used to complete the connection?
Yes, sir.
All right. And does this particular item that's on the screen now, does it look like something that would have been around in 1944?
Yes, sir, on the rail cars, because everything over there were I'd say antique, not antique necessarily, but they used old equipment. The equipment they used in the rail side was not equipment like we used on Atlantic Coast
All right.
Line.
Let me show you a different object here. I'm going to try to get a little closer. Can you see that picture, sir?
Yes, sir.
There you go. Go the other way. Okay. Let me zoom in for you. There you go. Now, this is a different type of metal object. Can you tell us what that is?
That has the appearance of a drift pin also.
All right, sir. And would you describe it as you see it on this picture? About how long does it appear to be?
I cannot see the markings on the rule
All
on
right,
the
sir.
scale, but it would be in the vicinity of 12 inches,
All right.
11, 12, 13, somewhere in that neighborhood.
Is it a flat object, or how would you describe it?
No, sir, it's a round object, and as I can recall, those pins were approximately probably an inch and a half, it could be as much as 2 inches in diameter, and 12, 11, 12, 13, 14 inches long, really depending on the size of the receiver.
All right, sir. And the receiver would be something on the railroad car?
Yes, sir.
All right. And were they commonplace, these pins, back in the 1940s for joining the cars together?
They were commonplace on the log cars.
All right, sir. And the log cars would be hauling,
Just hauling, they used them to haul logs in and out of the swamps.
all right, and take them to the sawmills?
Yes, sir.
All right. Did Alcaloo have a sawmill in 1944?
Yes, sir.
All right. Do you know who the name of the company?
Yes, sir, Alderman.
All right, sir. Now, did you ever work for the Alderman Company?
No, sir.
All right.
I did a little yard work for Ben Alderman, who
Right.
was the CEO there, but no, I did not work for them.
And so, if somebody told you they found a spike, you would have, is it your testimony that the spike is a great deal, a difference in size and dimension
Oh,
than
yeah.
this
Oh, yeah.
article called the drift in?
Yes, sir. Yes, sir.
Did Atlantic Coastline Railroad run a railroad track through Alkaloo in 1944?
Yes, sir.
Was there a depot there?
Yes, sir.
And what was the depot for freight as well as passengers?
I, yes, it was. It was a flag stop for the passenger service, primarily freight, local. But we did have a passenger train that ran from Columbia, Sumter, Lane, into Charleston at that time.
All right. I thank you for coming today, sir, and I would ask you to answer any questions that this lawyer might have.
Thank you.
Thank you, Your Honor. Pleases the court. Mr. Ridgway, how are you doing today?
Fine, sir.
My name is Steve McKenzie, and I represent the family of George Stinney. You said you were 13, I believe, when you were growing up in Alkaloo. Is that correct?
I was 13 while we resided in
Okay.
Alkaloo, yes.
So you were 13 when you moved back to Alkaloo?
No, we moved to Alkaloo in 43, in the early 43.
Okay. So my next question, I'm sorry, you moved there in 1943, is that correct?
Yes, sir.
Okay. So you were there whenever the murders of the Timms girl and the Binnicker girl happened?
Yes,
You were
sir.
living there?
Yes, sir.
And you remember that event quite well, don't you?
Yes, sir.
Okay. And you remember that the community was an outrage over this, is that right?
I wouldn't use that term, I don't think.
People upset?
It was not a common occurrence, put it that way.
Well,
I can't say that they were upset. I didn't see anyone angry, or they certainly were disturbed.
So two white girls in a small town killed, murdered, their heads were bashed in, and nobody was upset?
I didn't say no one was upset. I did not see any anger displayed.
Okay, nobody was angry over that issue?
I did not see anyone angry.
Okay.
It certainly was not a pleasant situation. Yes, it was sad.
Okay.
The little 8-year-old girl
And no doubt about it, was sad. But your testimony today is in a small town such as Alkaloo, we have a map here, and we're going to talk about that in a minute. Nobody was angry, they were just sad.
I didn't say no one was. I said I did not see it.
You didn't see it, okay. But you were 13 years old, and you remember the events of what happened on that day well, right?
Yes, sir.
Okay. Now, Alkaloo, the lumber mill, did your dad work, he worked with the railroad, was he in charge of the spur that ran around the lumber company?
No, sir.
All right. Do you remember the spur that ran around the lumber company?
Yes, I guess I'd say yes. I know they had a railroad over there. I saw it, and
How long did you live in Alkaloo?
we lived in Alkaloo until 45, I believe. 45, maybe 40, 45. Then they eliminated my dad's job in Alkaloo and relocated in Manning.
Right.
So they, of course, moved us over to Manning. But
So you lived there 2 years. You raked Ben Alderman's yard. Did you play in the neighborhood?
sure.
Did you play with the black children?
Yes, sir.
Okay. And you played with the white children?
Yes, sir.
Okay. And do you remember George Stinney?
No, sir.
Okay. You never played or interacted with him?
Not know it. No, sir.
Okay. Now, come down here a second. Let's take a look at this board. This is something that's been marked as a exhibit but not introduced into evidence. Can you locate the railroad spur that would have come off? And you're a railroad man, right?
Yes, sir.
First of all, show us where the railroad, the main railroad line would have come through Alkaloo.
Right here.
Okay, and you're pointing from, and I guess
From Manning side.
to going towards Sumter.
Yes, sir.
Okay, and this is and it's delineated by two lines that are going this way. Is that correct?
That's correct. Yes.
Okay. Show us where the spur would have come off of there.
It would have been in this area right here.
Uh-huh,
come down around the depot,
right,
and then went off into the mill.
okay. Is a spur on this map?
I don't see it.
Okay, so this map doesn't accurately reflect the railroad lines at that time, does it?
No, sir, I don't see the spur on here, no, sir.
Okay, let me ask you this question. You remember the watchtower for the company, right?
No, sir.
You don't remember a watchtower being there?
No, sir.
You don't remember their tower being by the log pond
No, sir.
at all?
No, sir, I don't remember it.
But you lived there 2 years, right?
Absolutely.
Okay, and you don't remember a watchtower?
No, sir.
Okay, but you remember a spur, right?
Yes, sir, because we live right here.
You live right on the spur?
Yes, sir.
So you live right down here?
Yes, sir, right at this intersection right here.
Okay, and so this map, as far as you're concerned, doesn't accurately reflect the railroad tracks on that day?
It reflects the main line that I don't see the spur on it, no, sir.
Right. Let me ask you this question. This has got Hotel Street running into Plowden Mill Road. Is that accurately reflected on this map? Does Hotel Street run into Plowden Mill Road?
I can't tell you that.
Well, you lived in Manning, do you know that?
I lived in Alcaloo also, but
Okay.
I don't know what road it runs into. I never had an occasion to go out that road, to be
Okay.
honest.
Do you see, do you remember Green Lawn Baptist, or Green Hill Baptist Church?
Yes, I know where it is.
Do you see it on this map?
No, sir.
Okay. So this map doesn't accurately reflect Alcaloo as you remember it?
That map doesn't extend out far enough to include that church, I don't think.
So the church would have been way over here?
Yes, sir.
Is that what you're saying?
Yeah,
Okay. And you lived over here,
I live here.
right? And so, and the spur would have run, tell us where the spur would have run to.
The spur was just a siding
Right.
from here to just beyond the depot.
Just, so, in your remembrance of this, the spur was over here, and so if anything happened over here, it wouldn't have been anywhere close to any railroad tracks. Is that correct? Or any spurs, anything having to do with the railroad company, is that correct?
I didn't follow, I didn't follow you.
Okay, let me back up. And sometimes I ask poor questions, and I apologize for that. My question being, there were no other railroad-type structures or tracks that you know of beside the main line coming through the middle of Alcaloo or the spur which went into the lumber yard?
There was some tracks back behind the mill.
Okay?
I had a brother-in-law that lived down this road,
Right.
and there was a dirt road that broke off to the left that went by his house, and the church was just below his home.
Right.
I don't see it on here, I can't identify it.
So you don't know where, but there were tracks there too?
There was tracks beyond the church, to the left of the church.
Right.
A little yard, little storage tracks. for the
Right,
mill.
but wasn't that a part of the lumber yard?
The old part, I guess.
Okay, well, do you remember the log pond?
Not really, no.
Do you remember this being the lumber yard right here?
Yes, sir.
Okay, so the tracks are not reflected on here, am I correct on that?
I don't know. I don't know what the track layout was in the mill because we didn't have an occasion to go in the mill. These tracks in the mill was owned by Alderman, a lumber
Right.
company. The Atlantic Coast Line, or my dad at the time, had nothing whatsoever to do with any of the tracks beyond the spur, side spur, and the connection switch.
But you can tell me that you lived here beside the spur, and that spur is not on that map.
I can tell you that, yes, sir.
Okay, you can have a seat. Mr. Ridgway, you talked about the length of these drift pins. Am I mispronouncing that?
No,
Is drift or
they were commonly known as drift pins,
Okay.
but I think the correct term was draft or link pin.
draft or link pin? And there was two images that the solicitor showed you. Is that correct?
Yes, sir.
Okay. Now, is it your experience if say you were to walk down a track of railroad that you could find spikes, railroad spikes, about every couple of feet you find one or two?
Not necessarily, you see them in the ties,
Okay.
in the rail ties, but you wouldn't see
You would see them come loose?
Occasionally, I wouldn't come loose, but
Okay.
it's not a
Because
common thing on
It's
a
not
piece of
uncommon.
railroad.
It's not uncommon on a railroad for the spikes to work themselves loose. Because the train, when it goes through, it's heavy, it's moving the track back and forth. Am I correct on that? And sometimes these spikes work themselves loose.
Yeah, the tie deteriorates, yes.
Okay, great. Now, I would suppose that if a drift pin or a link pin was missing, then two cars would not be connected. Is that correct?
If the drift pin from a particular car was missing, no, sir, it would not stay connected.
Okay. So my question then is, how does someone get their hands on a drift pin or a link pin unless they pull it out between the two cars?
Those pins would not have been on the spur to begin with.
They wouldn't have been where?
They would not have been on the spur track, our track.
Okay, so they wouldn't have been on the spur track.
It would not have been on the coastline spur, no,
Okay,
sir.
so they would have only been where?
In the mill tracks on the mill railroad.
Okay, and we've already identified on the map that that's that line right here, is that right? And the one that comes over here?
That is the Atlantic coastline.
Right. So for someone to get one of those pins, they would have had to go and get it off of one of these lines, is that correct?
Or a car in the storage yard over there.
Okay, or in the storage yard. So they would have had to go into the lumber company itself to get that. Is that correct?
They'd have to go on company property.
Okay. Were you allowed on company property?
Well, I'd never went on company
My
property,
question was,
knowingly.
were you allowed to go on company property? If you went on company property, if someone stopped you and said, hey, what are you doing here? So you can get hurt out here. Did you ever do that?
No, sir.
Okay. Was it understood that you knew you couldn't go on company property?
My dad told me that.
Okay, all right. So the only place that one of these pins that the solicitor has shown us that could have been found would not have been found on the spur, is that right?
That's correct.
Okay, now what would have been found on the spur? Could a spike have been found on the spur?
Sure.
Okay. You have a hammer at your house?
Sure.
I have one too. So, how long's the hammer?
How long is the handle or the hammer?
The hammer's usually connected to the handle, but if you want to qualify those two, that's fine. But let's say it's together.
Okay.
Okay, how long is that hammer?
.12 inches.
Okay.
Give or take one.
Right.
Two.
Court's indulged, Your Honor. No further questions, Your Honor.
Thank you, I appreciate you coming, Mr. Ridgway.
Any
Move that he
objection?
be excused.
Any objection?
No objections, Your Honor.
You're excused, sir. Thank you.
Call Ms. Frankie Dykes to the stand.
Come on forward, Ms. Dykes.
Place your left hand on the Bible, raise your right hand, state your name, please.
Frankie Daly Dykes.
Solemnly swear or affirm your testimony to the court to be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Thank you. Have a seat, Jeffrey. Please state your full name, spell your last name for the record.
Frankie Bailey Dykes, D-Y-C-H-E-S.
Good afternoon, Ms. Dykes.
Hello?
You can back up just a little bit for that. I believe you're going to be able to talk loud
I
enough.
have a loud voice.
Very good. Ms. Dykes, where do you reside?
Goose Creek, South Carolina,
And have you lived there all your life?
since 1964.
All right. I'm not going to ask you if that's the year you were born. I'm just going to assume it was. Do you know the name Betty Jean Binnicker?
Yes, I do.
How do you know that name?
That was the 11-year-old baby sister of my mother,
And tell me your mother's name.
Lorene Benica Bailey.
And was Miss Lorene, your mother, born in Alcaloo, South Carolina?
Yes, as
All
far
right.
as I know.
And do you know what year she was born in Alcaloo?
1922.
1922. And your mother, Lorraine,
Lorene.
pardon me?
Lorene. L-O-R-I-N-E.
Lorene.
Yes.
All right. Did she go to school there in Alcaloo?
She did, but she ended up graduating her last year in Holly Hill.
Holly Hill. Now, can you tell me if Miss Lorene married?
Yes.
And when she married, where did she and her husband reside?
Well, Dad was in the Army, so she stayed with my grandmama. My brother was born. He was 10 months old when Betty Jean was killed.
All right.
So they were there. Dad was still in the Army.
All right. So your mom and dad, the firstborn, I was going to get to this next, the firstborn child was a son,
Yes?
and he was 10?
No, he was 10 months.
I'm sorry. I heard you say 10. He was 10 months old
Yes.
at the time of the death of Betty Jean.
Yes.
All right. And after the 10-month-old, were there other children?
Yes, me next.
You next.
Yes.
And then were there other children after you?
I have 2 brothers that are younger than me.
All right. And are some of these people in court with you today?
2 of my brothers.
All right, very good. I asked you to bring photographs of Betty Jean from your family,
Yes.
and did you do that today?
Yes, I did.
All right. Could you tell the judge what's been marked as states number 3, which is a 5x7 color photograph, who appears in the photograph, and tell us a little bit about the history.
This is Betty Jean. I think this was probably taken when she was about 8 or 9. She was the baby of the sisters, of the family. She had 2 older sisters and she had 2 older brothers.
All right, and I want to show you states exhibit number 4.
This we think was taken the summer before she was murdered.
And she would have been about 10 years old when that picture was
Yes,
taken?
her birthday was December the 9th. She was 10 years younger than my mother.
All right, and 10 years younger than your mother?
Yes.
All right. And that's states exhibit number 4. Now, do you know where Betty Jean lived at the time in 1944 when her life was taken?
She lived with my grandmother and my grandfather
And
in
was that
Alcaloo.
In Alcaloo?
Yes.
Do you know what street that was on?
Hotel Street?
On Hotel Street?
Yes.
And do you know whether or not she had neighbors, other children?
Yes.
Mary,
Mary Emma was the next door neighbor.
all right, Mary Emma Thames is the other young lady who
Timms,
lost her life?
yes, yes.
All right. And the name is spelled T-H-A-M-E-S,
It's pronounced Timms.
Timms. And your information is that Miss Timms was a next-door neighbor to your family member, Miss Benniger.
Yes.
Would you tell the judge how this case, having been resolved in terms of the trial, you weren't alive in 1944.
No, I was born 2 years later.
How has this case affected you and your family members in terms of its being resurrected every 10 or 15 or 20 years?
We never dwelled on it daily. We always knew that our aunt was murdered and her friend, and we always knew that it was George Stinney Jr. My mom never, my grandparents to begin with, never recovered. That was their baby daughter. That was my mother and my aunt and my two uncles' baby sister. They doted on her, and they never, ever recovered from that. And as far as coming up, this has been coming back and forth for as long as I can remember. And we never responded to anybody because we just thought it was it'll go away. But when somebody told me that my grandparents had taken money to shut them up and be quiet and that they knew the true murderer, is when I got mad and angry and hurt. How my grandparents were as poor as church mice. They worked in that lumber mill and they picked cotton. And to even suggest that they took money, no, do not tell me that.
Do you think that has it been helpful in resolving some of the feelings that your family and you harbor to go through this hearing and to have the judge listen to this evidence at this point?
How do I feel about it?
Yes,
Or
ma'am.
has it helped me?
Yes, ma'am.
No, it's not helped me. I've heard stories here that I believe are false. It doesn't change my feelings about what happened.
Do you and your family members who are present today know of people who were alive and saw things and heard things and were part of the community in 1944 that could have been helpful to the judge had this case been brought years ago?
Yes,
And are those
Yes.
people still alive and well now?
yes, my mother only died 6 months ago. She was 90 and had perfect mind. She could have told them anything they wanted to know. We were told when I called.
What we were told.
Don't go into what you was saying. Let me ask you this. Did you have occasion to meet one
No,
of the...
but I was told that,
You can't talk about what somebody told you, I'm sorry.
okay, sorry,
We've
sorry.
been through this. Did you have the occasion to meet a Mr. Pratt who was an investigator on this case in 1944?
Yes, I did.
All right. And do you know when Mr. Pratt died?
Oh, my goodness, probably 10, 12 years ago.
10 or 12 years ago. And he was still alive, as far as you know. When you met him, was it shortly before his death or a long time before his death?
It would have been when Carolina Skeletons came out, which I think was in the early 80s.
All right.
I might be wrong
All right.
on that.
So sometimes around, let's just say if it was 20 years ago,
Oh, yeah,
1984.
oh, sure, yeah,
You, Mr. Pratt, the still living in South Carolina.
yes, Moncks Corner.
Do you go back to Alcaloo regularly? Do you have friends or relatives there now?
No,
Has Alcaloo changed a lot over
It
the last
looks-
20 years, would you say?
it looks absolutely nothing like I remember the last time I went there. There's nothing, no portions of the mill that I could tell. Most of the houses, all of the houses are gone.
Are you and your family satisfied with the way the system worked in 1944 as far as the trial, as far as you know, since you weren't alive then? Based on what you know, do you have any concerns, or are you requesting this judge to do anything different about the case based on concerns that you have, or are you in favor of keeping the record as it was, as it existed, as a conviction, and keeping the case closed?
I believe that he confessed, he was tried, found guilty by the laws of 1944, which are completely different now. It can't be compared, and I think that it needs to be left as is.
I want to thank you for coming today. I want to
You're
thank your family
welcome.
members for supporting you,
You're
and I want to
welcome.
ask you to answer any questions that the defense may
I
have.
will.
Your Honor, before I sit, I would like to move these two color photographs into evidence as State's Exhibit number 3 and 4.
And we have no objection.
Without objection, they're in evidence.
Oh, sorry.
Ms. Dykes, I think you were not around when was she your great aunt?
My aunt,
Your aunt.
my
When she-
sisters,
when she
my
was-
mother's baby sister.
When she was killed, you were not born.
No, not until 2 years later.
Okay. And you believe that George Stinney got a fair trial?
I believe that from what I've learned
Mm-hmm.
and what I was brought up with, I believe that back then, yes, I do.
Okay. So you believe that it's okay that a young black 14-year-old boy was brought into a court of law and prior to that was not allowed to speak with his parents but while he was being interrogated by the police. You think that's okay?
I think that he was 3 months short of being 15, and I think yes.
So you
That
think
he-
that's okay?
I think
You
that
have children?
I do.
And would you be okay with your 14-year-old being taken into a police investigation and questioned without you being present?
Knowing my children, yes.
Okay. So you think that's okay?
Yes.
All right, would you be comfortable with your 14-year-old, if you have a 14-year-old,
I have a 48-year-old.
okay, when he was 14?
Yes. He
Would
was
you
working.
been okay
Okay.
with your 14-year-old being tried by 12 black men and he was the only white person in the courtroom?
If he had been arrested and they had and he confessed, yes, I would.
So you have no problem with that?
At 14, 3 months short of being 15, my son would have known better. And he was not mean.
Okay. But
No,
when-
he would not have, I would think that you live by the sword, you die by the sword.
So my question to you is that your son's facing execution.
It would be hard, but my son would know better at that age.
I'm not asking you whether or not your son would know better. I'm asking you, would you be okay with that question? Would you be okay
I
with
would
that?
live with it.
I'm sorry?
I would be hurt, I would be very sad, but I would live with it.
Would
I
you
would
like to have
accept
been,
it.
would you like to have been present in the courtroom?
Then?
Okay. And are you?
Oh, you mean this is if my son?
Yes.
I
At
probably
14.
would not have even wanted to have seen it, no.
Okay, so you wouldn't want to see that?
No, I wouldn't.
Okay.
I would accept it.
Okay. And so you're okay with the way this trial procedure was handled?
I don't think that that was the only one that was handled that way in 1944. That was, some people didn't even get trials that were accused of this.
Okay.
Okay.
And we just summarily executed them, we didn't give them trials?
I didn't know anybody that was executed
But you said some people didn't get trials back then.
according to what I've read.
Okay, according to what you read, so.
Yes.
So what the state did, as opposed to giving them a trial, they just, when I say summarily execute them, they just didn't even have due
I don't
process?
think maybe the state did it. I think other people did it, their peers.
Oh, their peers, so that was lynching back then, is that what you're saying?
I think probably maybe walking the plank at one time, lynching at one time,
Walking the
shooting
plank,
in
lynch-
front of a,
So
Mr.
my,
McKenzie, I've given you a lot of latitude, but we need to bring it back. And again, you're asking her to talk about constitutional and legal issues.
And
She's
I
not a
will back
trained
away.
lawyer.
I'll back
So
away.
we need to wrap this up. I
I
gave
will.
both of you a lot of latitude in putting this up here, but I want to make sure what we've got is appropriate.
the only other question, you've discussed the fact that sometimes trials are good and sometimes they're not appropriate, right?
did I say that?
I think you said that sometimes it's okay not to have a trial. Isn't that what you discussed earlier?
I object to that, Your Honor.
Okay, sustained. That's not what she said.
Okay.
You need to ask her a question.
Do you think it's okay to lynch someone for a crime without a trial?
No, I wouldn't lynch anybody.
Okay, that's all the questions I have.
No, perfect.
All right. Any objection to Ms. Dykes stepping down from anyone?
We request that she be excused.
All right, ma'am, you may be excused if you wish. Thank you.
Thank you.
Your Honor, the final issue, I thought we had taken care of this earlier, because Mr. McKenzie wasn't here, but I did ask the court to allow me to move this map, or copy of the map, into evidence, and you requested that over the lunch break, I get a copy from the copy shop of the map. It's already been marked as exhibit number 1. It hasn't been moved in, but I'm hereby moving this map in for the references that have been used by the witnesses.
Mr. McKenzie, you weren't here when Mr. Chandler agreed to it, and what we talked about in what was testified to by witnesses was there are some differences in the map, and I think we can all agree, and I think all the witnesses were clear and testified that on the larger map it doesn't show the dirt road going by Green Hill Baptist Church, but on the smaller one it did, and I don't think you were here for the benefit of that. So we actually had the combination of the two maps, which were both testified to in this. So again, what Mr. Finney had asked me was, the map is borrowed from someone, and he wanted to return the actual map, and I said only if he is able to get an exact copy of it, same size, everything else, from a blueprint shop or whoever can print that for us. So, subject to that, do you have an objection?
No, ma'am, I don't.
Thank you.
And I think it goes to weight. You heard the testimony.
Clearly, I heard the testimony, I can compare, and I think the witnesses very well stated what was not on that map and what they could and could not remember about Alkaloo, and so I think it's clear for the record.
Thank you, Your Honor.
Okay?
Thank you, Your Honor.
All right.
We have no more witnesses.
Okay. May I see the attorneys? Into the lunch hour, but I am endeavoring to finish up this hearing. I do have other matters to take care of here in Clarendon County beginning at 2 o'clock. And because we do have to have those matters heard today, we do have people being transported. We're going to go ahead and go forward. I'm just going to ask both sides to just make a brief statement or comment in regards to, for the defense of the motion, from the state, their defense of the motion, and I may have a few questions, so forgive me, Mr. Shealy and Solicitor Finney, if I interrupt you. But certainly they are questions that I have. But if you want to go ahead and begin, I am happy to hear. Okay? Mr. Shealy, I may be able to help you or direct you into what I'm looking at. This case was originally brought as a Rule 29B after discovered evidence motion, and as you know, the requirements for a Rule 29B require that whatever the after discovered evidence is, it must or be likely or probably to change the outcome of the trial, that it had to be discovered since the trial or after the trial. It could not have been discovered before the trial by the exercise of due diligence, and then obviously it has to be a material issue in the case, and finally it can't be just cumulative or impeaching. Your second subsequent brief that I received, and unfortunately I didn't get it until almost Sunday night or Monday morning for the simple fact that the court's computers were down over the weekend, was the idea of bringing this case on a writ of coram nobis, which I understand you were the one that provided the brief on that. Obviously, we've done the research. I don't think the solicitor has had quite the opportunity to do it that everyone else has, and I am going to allow him an opportunity to brief that for me. But as you know, the principal function of a coram nobis is to correct an erroneous fact in the record that was not known when the judgment was rendered, which couldn't have been presented by a motion for a new trial, appeal, or other existing statutory proceeding. It can't be an ineffective assistance of counsel. It can't be certain things. Of course, it also doesn't lie for the fact, and it can't be for newly discovered evidence. So my question becomes, what are you relying on at this point? Having heard the testimony, I didn't require you all to elect and I needed to go forward to hear what in fact y'all were going to put forward as evidence and testimony in this case. What in your opinion is what is your strongest case, or what you propose or are asking me to do?
Excuse me. I think the court can consider the case as a writ for a motion of coram nobis. It is very clear from the case law, and I would like to quote some in just a moment. I'm remiss about doing that in trial court. I know that you can read it, but I want you to be clear about some of the hard black letter law, some of it, that we're relying on for coram nobis. And we think that one way to look at this is a coram nobis. Virtually every issue we've raised or presented evidence for and testified to that we've attached to motions is appropriate by way of coram nobis. And if I may, start just before I get into those details, what I think that Your Honor can hear. We filed this with you. It was sent. The solicitor should have copies. And I had been on this case a little more than a week myself. So nevertheless, we're glad that you may let us brief something after the fact if you think that's appropriate. United States versus Morgan, a 1954 United States Supreme Court case. The United States Supreme Court waxed eloquently about coram nobis in that case and made it very clear that coram nobis still existed under the Federal All Writs Act. And that's not relevant here, the All Writs Act. That's federal law, understand it. But why it is relevant here is because this case, as well as cases we've cited from the South Carolina Supreme Court, make it absolutely clear that coram nobis is part of the common law. There's no question that in South Carolina, unless the common law is changed or altered, as it has been by South Carolina Rule of Civil Procedure 60, which is irrelevant, we still have these motions. And coram nobis in particular, the case is worth reading closely. The problem here in Morgan, and I will just read a couple of bits of language that I think are relevant for the coram nobis and a criminal proceeding generally. The court starts off discussing it, and I believe it's, let me just be clear for the record, I'm quoting from the U.S. Reporter. So the case would be on page 506. The court says, beginning of the paragraph, we think a belated effort to set aside the conviction and sentence in federal criminal case is shown. Notice they say it's a belated effort because coram nobis, that goes to the timeliness. It's belated here. It's late. They realize that. And I'm going to dwell on that a bit more with black letter law. The court can read the whole thing. I won't belabor you, but I just want to be sure we see certain language. Footnote 4 of that same opinion, such a motion, referring to coram nobis, is a step in the criminal case and not like a habeas corpus where relief is sought in a separate case and record, the beginning of a separate civil proceeding. So that's why we're still in the old criminal case as this is, while nobody's alive, very few people, this is the same court actually sitting today that convicted Mr. Stinney. And then lastly, I would point to, and it is found on the end of page 507 in the official reporter, and there's much more language important, but I want to read this into the record and discuss it in detail. The United States Supreme Court said, the writ of coram nobis was available at common law to correct errors of fact. It was allowed without limitation of time for facts that affect the, quote, validity and regularity of the judgment and was used in both civil and criminal cases. While the occasions for its use were infrequent, no one doubts its availability at common law. That's the first quote I want to give you because statute of limitations and timeliness issues, and I will, if I'm allowed, talk much more about that, are not the same for coram nobis, even as they are for habeas and post-conviction relief. I think the court should have, if you don't, I cited it in my memorandum, it's easy to find, Solicitor Finney. I would recommend a good outline of this and discussion of the law is in Amjur. It's a very good work, and generally this is found at, which I've cited in my memorandum in part, 18 Amjur under Trials 1. And there are about, under that section, 1 through 46 sections dealing in detail with this issue. And I would like to direct the court's attention, if I may, and again, I regret to have to try to read so much, but this is really the core of the black letter law. Not all of it, but the core. And I look at section 27 of Amjur, which I find, looking at the cases, adequately sets forth the black letter law on this issue. The section heading is time for submitting application of coram nobis. And it says, as a general rule, relief by writ of coram nobis is not governed by any statute of limitations and can be applied for at any time. And it does go on to say subject only to a showing of reasonable diligence. The main considerations that govern the effect of a delay in applying for a writ are whether the judgment complained of is void or merely voidable. I will discuss that in a minute. And two, the nature of the specific grounds which the application for the writ is based. And the reason those are important, because for some, timeliness is not an issue. For some, it's only reasonable diligence, and that's the only standard. And we maintain that's a de minimis kind of standard. This discussion goes on to say, if I may, a void judgment gains no validity from the passage of time. Therefore, a prolonged delay in applying for writ of coram nobis to attack such a judgment ordinarily will not bar relief. We have real problems with the actual judgment and how that was obtained in this case that go beyond ineffective assistance or any kind of after discovered evidence. They go on to say, though, if the judgment is not merely void but is voidable, then reasonable diligence may be required in such cases, and that's different between a voidable and a void judgment. We actually think there are reasons for both in this case, that it is void and voidable. Next, Your Honor, the court here, the section of law here citing many cases in the last paragraph, says the particular ground for which a petition of coram nobis relief is based will also often determine whether delay in applying the writ relief will, delay in applying for the writ relief will bar relief. If the petition is based on such grounds as the violation of petitioner's right to counsel, or the inducement of a plea or of guilty through fraud, deception, mistake, duress, or fear, or the knowing use of perjured testimony, or some other ground showing a clear denial of due process, the petition can usually be made at any time, and they go on to cite thereafter, to be fair with the court and the solicitor, that there is some split on that, although that's the general rule. With that in mind, and without reading any more of this, but not withdrawing what we have said already, I would ask the court to remember that this is a last-ditch remedy at law. It is special, and it is in the nature of equitable relief. Now, if I may start off with what I think the state's contention might be here in terms of timeliness and what is going on there. I think, with all due respect, what we really mean by timeliness is prejudice. What we mean by timeliness is what we refer to in civil court as laches. At least that's the way we pronounce it in this part of the world. It's French, so I'm not sure if that's proper pronunciation. But it's laches. What does that mean? That's what goes on in post-conviction relief. The court has recognized that laches can be a defense there. That's really what I think we're talking about. The importance is the prejudice that is shown. And the solicitor has mentioned the evidence that he does not have. But I must say this before I go on to specific facts we're relying on. As an equitable kind of remedy that slips in through coram nobis into the criminal section, in equity, whenever a party asserts an equitable remedy, it must have clean hands. If you don't have clean hands, you don't get to assert an equitable remedy. That's basic equity from law school. Now, I want to be clear. I want to be absolutely clear. We're not accusing Solicitor Finney of any wrongdoing at all. We're all born well after this. We're not even specifically zeroing in on the trial judge at the time, though I have doubts, or the solicitor at the time, though I think there's some serious doubts. But we're talking about the state of South Carolina as an entity. It's not about individuals. It's how this entity treats criminal defendants. It is the state of South Carolina's responsibility as an entity to maintain due process, to maintain the rule of law, even in 1944, about how things are done, irrespective of any misconduct by any individual. The problem here is that we believe the state as an entity has very unclean hands, and we think we have shown that, at least that, by a preponderance of the evidence, which will be the standard under coram nobis. And if the state has unclean hands, it cannot, just like anybody else in equity or any other kind of remedy, cannot come into court and say, oh, you can't raise that claim against us, it's late, we're prejudiced, we have an issue here, we can't defend about that. If the party claiming that is partly responsible or is at fault for bringing about the problem that led to the claim, you don't have the equitable remedy of laches, of prejudice to argue. We think that's a serious point here that the court has to consider. Now, with respect to that, what precisely am I talking about? Again, going back here to the distinction between a void and avoidable judgment. And there are certain facts that have been stipulated to. That's over. There are certain facts we think we have proven by a preponderance of the evidence in this courtroom in the last 2 days. First, the voidable judgment. There is a serious issue about the way the coroner's inquest was conducted and the grand jury indictment was reached, and about how that was done. And we believe even in 1944, a proper lawyer doing their job of court should have recognized that indictment probably should have been quashed. Whether or not they could go back and get another one is irrespective. They did, there was serious problems with the constitution of the grand jury given the coroner's inquest, and that's not disputable before the court. And if that indictment is thrown out, that court did not have jurisdiction in 1944. That judgment is void. And that can squarely be addressed by coram nobis, because that goes to the record before the court at the time, which is still before this court today. That is a tremendous problem. So that's voidable, and we submit under the clear black letter law without exception. Coram nobis would not even require reasonable diligence on that point, because it's still a judgment that's maintained. It's still maintained today. It's as much maintained today as it was in 1944. So those are important considerations before the court. Now, what other kinds of considerations might make this voidable, so that we're clear? And I'm hoping that perhaps the court will hear a bit from Mr. McKinney, Mr. McKenzie, who knows more about the detailed facts than perhaps I do. But a laundry list, and you've already heard it, it's not only what's stipulated to, it's what's before the court. There are serious issues about, even then, the murder occurring so quickly in March, and him being actually executed 81 days later. The fact of there is no, we talk about this record of the trial, we can't even read it, but what we know is there no witnesses called on George Stinney Jr.'s behalf, and there's no cross-examination. I think, right, and that's the third point. And that's probably why the transcript was not transcribed. I do not know how transcripts were maintained in 1944, but,
They were by shorthand.
I would think so. And probably no machinery, and the file would have been destroyed, especially if there's no appeal. It would have never been done. But the notion, even in 1944, that you would not have taken an appeal from a case like this or asked a question or called for a witness really shocks the conscience, and it should. Forget the criminal procedure revolution that took place afterwards. That's all we think is a serious problem that could have, for a habeas, for anything in 1944, or a coram nobis, which, yes, existed in 1944. The problem then for us is that he is, by June the 17th, he is dead. Now, let's look at due diligence as it, reasonable diligence, as the law says, as it might affect the Stinney family. We have undisputed evidence they had to leave town. And we can debate how serious that was, but they left town and got out quickly for a while, and most of the family broke up. What would one have done from 1944 to the present? Was that family, were they unreasonable in their behavior? Because that's all the standard is. They have to just be reasonable in their behavior. And I think everything they did was reasonable. If you look at the facts before the court and you look at the pleadings, yes, there are some letters for clemency, but they don't articulate a lot of facts. There aren't people that are willing to come forward and be lawyers and defend the case. The Stinney family is poor. Their parents are poor. There were appointed counsel at the trial. They couldn't afford one then, even in 1944.
Mr. Shealy, let me ask you, one of the questions I've had is why the NAACP or the ACLU hasn't become involved in this case.
I cannot speak to that, but I will say this, with all due respect, I think that's entirely irrelevant what other people would do. We've got to focus on the parties, and the only ones that can be here is their family. I don't know when the NAACP came into existence, but certainly in the 1940s and early 50s, its influence was much less. A lot of these organizations, like the Innocence Project and others, exist only relatively recently. And, the problem is here we have a deceased defendant, which we've already discussed and talked about this. In terms of spending money and time, there's nobody to get out of jail for free. That's a problem. But
Clearly, they want to take care of people who actually are currently incarcerated and still living and spend their resources there.
Right.
I understand that argument.
And I don't think it is relevant at all what other people could or could not have done for the Stinney family. We have to look at what they could have done, what they had the power to do. Other people aren't parties. They certainly could not have intervened without them. But there's no basis to think that they behaved unreasonably. The only thing we really have is in the 1980s, and it's the late 80s when that book about skeletons comes out. And that's a novelization. The movie, I think, is out around 93 or 94, so we're already late in the game already. And let's be fair, I don't know what role they had in it. There's been no testimony that the Stinneys made it or made any money out of it. That somebody else did it, and it's a novelization, and a lot of facts aren't in the record. Most of it, I understand, is not true. But that's, in any respect, it was inspired by these events. So I don't know what effect a Hollywood movie presentation that's made for TV and a book that somebody writes really is noticed and constitutes a legal argument. That's the problem. The other thing is that I do know, when Mr. Frierson gets involved in this thing in 2004, that seems to be the first point, other than some spurious newspaper articles, which we've already talked about, are irrelevant. You wouldn't accept them here. We're not complaining about that. We get it. But as far as considering that notice for the Stinney family, the fact that we can't put them in evidence here, and a lot of the facts is perhaps why they didn't signal to the lawyer it was a problem. They dribbled out, and it's not many. It's hearsay. It's all kinds of problems with those. I don't think that's noticed. The only concrete thing that we see is in 2004, thereabouts, Mr. Frierson gets involved. We're seriously going out and questioning people and putting the dots together, and that's where it starts. And then someone has to consider this, and it's not long, I think it's 2009 or 2010, when the case comes to Mr. McKenzie. And, you know, you get a case like this, and you start putting together a 70-year record, worrying about interviewing people and trying to do some legal work. I don't, certainly whatever happened in the 2000s today cannot be counted against the Stinney family. They still haven't retained a lawyer. They still haven't paid an investigator. And they're not in a position to do that, to mount a case like this. I don't think they were unreasonable in what they did, given the history, the circumstances, and what their family faced. And let's remember, none of them are lawyers, none of them are legally trained. And to this day, you know, even though I think the quorum nobis applies, when I tell people about what have you done, we've helped file a petition for quorum nobis. What? Even among lawyers. And it is rare, and it is unusual. And we have asked the court to exercise some discretion in that regard. But, you know, the bottom line for the Stinney family and most people is when that young man died on June the 16th at age 14, what could we really do other than suffer with it? And I think recently, only in the last, if you will, even 20 years, has the Innocence Project really started winning cases for living people. This is still difficult. It is still expensive. Most defendants can't afford this when they're alive. And so we don't think that there's anything, only the Stinney family can have been reasonable or unreasonable, not other people who don't have any duty to get involved with this. They were not unreasonable in waiting for this evidence to be put together. It's all really fallen in place since the early 2000s, if you really look hard at what's there that somebody's done, and maybe the mid-2000s, and it wasn't in place then. And it's been worked up and developed and reviewed, and witnesses have finally been called, and they're presenting themselves to the court. So in terms of setting aside the void part of the judgment, which is we submit there's no consequence, and there's serious issues there. But looking at why it's voidable, at the same facts, the way the Stinney family was treated in 1944, there's nobody disputing it was, let's just say, to put it overly mild, very, very poor by the state as an entity. They had no reason to believe for a long time that there's anything they could do to set this aside. And certainly there aren't a lot of cases in South Carolina, and not a lot brought. And most of them have brought in more recent times. So we think, Your Honor, we submit that, one, the black letter law is clear, that timelessness may not even be an issue, is not an issue on some of these standards, because we're setting aside a judgment that's still there. The second thing is, as to those reasons that might make it voidable, which have been testified to and argued, they have only recently been brought to fruition and developed very recently, and reasonably so, in a case of this nature. So the Stinney family is not unreasonable for doing this. I want to, and one other thing, just in summing up, and I'd be glad to take your questions or submit further briefing. Latches, it's not about, certainly about Solicitor Finney. It's not even about the solicitor at the time, though it should be. And it's not even about the judge at the time, though maybe it should be. It is about the state of South Carolina and whether they can really stand on the defense that we have clean hands and we assert an equitable defense to this. And I don't think that they do. And I think we've at least proven by a preponderance of the evidence that the state as an entity does not. And so that's a real problem with using that laches language. One other minor point. Laches and prejudice are the same thing. It's a bit different here. In the normal circumstance, we have a live defendant who can get a new trial. That's a strong case for laches and prejudice. The state's got to put witnesses up in to try this person. And they still have a problem, I understand that. But let's be honest. If you grant the relief we ask, and we think you should give us, it's an order vacating the judgment of conviction. We can't even ask you for an order to vacate the sentence because you can't. We can only ask you to vacate the judgment of conviction. I know the Stinney family wants more. You can't order a new trial. That can't happen. So that prejudice is really of calling witnesses for future trial is not before the court. It's about the prejudice, and there is some, and understand it, that the solicitor suffers in calling witnesses today. But we suffer from a lot of that too. And that's where the clean hands and the distinction between void and voidable judgments comes into play. And to the extent that the standard is there, it's only reasonableness as a de minimis standard. And this family, under their circumstances, about which there's abundant evidence in the record and in testimony, I don't think you can say they've been unreasonable in the way they've proceeded.
Okay.
Thank you.
Thank you. Mr. Finney, I'm going to go ahead and let you respond if you'd like. And,
Please, court.
yes, sir.
Your Honor, in the current case, the party withstanding on this matter was George Stinney. And although it may sound harsh, the fact remains that he's the only person possessed with the legal ability to claim standing to challenge the conviction and his right to present evidence. Standing requires that the party bringing the action suffer an adverse impact on their own rights, and that there is no one able to provide that in this current case. We
Continue, Mr. Finney.
in some of the research done preparing for this matter, we came across a case on abatement. And the abatement issue clearly, under South Carolina law, seems to say that once a person has reached their end of their life, the legal standing to request certain relief ends at that point. We thought that this might be an abatement issue as it related to the motion that was filed under 29B, only to be met at the courthouse door with the quorum novus argument. I would say, Your Honor, that the quorum novus argument cannot succeed in this particular instance because it is not a defect in the record caused by some type of judicial or some type of malfeasance. The only reason we have a defect in the record is because the court met its duty, concluded its business, the judgment was carried out, and the passage of time began to march. And some 70 years almost has marched by, which has lost for us the record and the evidence and the formal proceedings, so to speak, that would let us know exactly what kind of trial we had. The state at this time does not concede that we had dirty hands at all, either as a solicitor's office, as a judicial office, or as a state in development, because that's what we were in South Carolina in 1944. I would remind everyone here that only 5 years later, in 1949, members of the same Clarendon County community by the name of Delane and Briggs and Frierson banded together as black citizens and brought a petition that ended up being taken down to the federal district court in Charleston, acted upon by a federal district judge where they won initially. That was appealed to the Fourth Circuit where they lost, and that case was taken by Thurgood Marshall and other lawyers to the United States Supreme Court, ending in a ruling in Brown versus Board of Education. That happened in Briggs versus Elliott in Clarendon County in 1949. I am, as a a student of history, very concerned that the Stinney family takes the position that there wasn't any help available to them in 1944. I'm not saying that I was there, and I'm not saying it wouldn't have been difficult. But I am saying that I believe a concerted effort on their part and the part of other friends and family members would have been able to give them what they felt like they didn't have. Now, they did have a lawyer, Your Honor. They did have a judge and a solicitor. They did have a 12-member panel. By all accounts, it wasn't of the same race, but by all accounts, that wasn't a historical anomaly at the time in 1944. We have cases today that Your Honor hears on a routine basis where the defendant elects not to take the stand, where no evidence is presented. This was a double murder of two little girls who were out doing what little girls do on a spring afternoon. It was a horrific crime. It would appear that based on the evidence that we have in the record, the investigation led to George Stinney. We don't exactly know why, but it did. And after that, we are told that there was a confession, which included the finding and turning over of the murder weapon, and that a trial, not the next day or the next week, but 30 days later, a trial occurred in Clarendon County. During that period of time, he was appointed not one, but actually two lawyers. And that even though the trial was very short in duration, it did end with a verdict. And two things that I want the court to remember about this set of facts. Number one, the jury had an opportunity to, my understanding, to return a recommendation of mercy so that the judge could not sentence to death. And I want the court today to realize that the imposition of the death penalty was a critical factor in this trial, but it's not the only factor, and it certainly did not color the trial that preceded it. The fact of the matter is that the judge did what he thought was required under the facts of the case. That shouldn't taint the fact that the trial occurred and it occurred properly. The other thing that I want the judge today, Your Honor, to remember is that apparently the investigators weren't in such a hurry that they ruined two little lives of black men. Johnny was taken into custody, interrogated, and released. By their own witness, he was released an hour later. I'm not sure that's correct. I believe, based on what I know, that it was probably a longer time later. But the fact of the matter is they weren't trying to railroad every black person that was associated with Al Kalu and these little girls. They made a determination based on facts that we don't have today that George Stinney should be retained and dealt with by the legal system and that Johnny should be released. Your Honor, reasonable diligence, my co-counsel in his learned effort, he used the word unreasonable, referring to the Stinneys. But the word really is reasonable diligence, and he needs to turn the mirror of his argument around because it wasn't reasonable. As I have said earlier, by 1954, this community would have been able to bring a challenge by the NAACP or some other like group. Certainly by 1974, when we had African Americans serving on the circuit court bench in this circuit alone, we would have had opportunities to have review. The problem is that the prejudice is not to the Stinneys. The prejudice is to the state because we have to defend the action that took place in 1944, which means we need to have our witnesses. As our testimony took place today, Mr. Pratt was alive and living in South Carolina. He was the governor's special investigator that was sent down here. We don't have testimony as to when Mr. Newman passed away, but certainly these men and other witnesses in the case would have been prepared and able to tell a judge sitting in review what happened and what the missing pieces were. We think that it is a clear denial of our due process to rest on the judgment for them to come forward now and say because a 14-year-old was executed, which is the second phase in my argument of this claim, not the first phase, that his due process was denied. We are still looking at this case through present sense interpretations of law. we're using the rules that we work with today to evaluate a case that happened in 1944. I do not believe that we have clear and convincing evidence of a void judgment. We do have evidence that a man served on a coroner's inquest, and that same man may have had his name as one of the significant number of people who was on the grand jury. We have no evidence that he passed judgment and voted for the indictment. It is clear from his name being struck from the indictment in the records that he did not testify, well, at least it's clear to me. I'm sure there's an argument about it, that he did not testify at the trial. We don't have any record that he participated in the trial proceedings, and we're certainly clear that he was not one of the 12 petty jurymen who returned a verdict in this case. Your Honor, we would take and appreciate the opportunity to brief this matter so that we can do some more research, but we would contend at this point that there has been a failure of clear evidence to move the quorum nobis argument forward, and we would ask the court to keep the matter as it is now, keep the record closed and the judgment intact. Thank you.
Mr. Shealy, do you want to respond briefly, or are you comfortable to sit?
Would you know in one moment, please?
Yes, sir.
Just a couple of things, Your Honor.
Yes,
if I
sir.
may, not to belabor the point.
Yes, sir.
I respect Senator Finney's argument, and I respect the very difficult position that he is in today. However, the standard here is, I think, under quorum nobis by a preponderance of the evidence. I think that where reasonable diligence does apply, there are only two findings. One was reasonable, or one was unreasonable. I don't know of an in-between, and the court can search Merriam-Webster's, the Oxford English Dictionary if it wishes, but that's it. To find that one was not reasonable is to find that one is unreasonable. I think that's just common usage of words. And I don't think that there's anything unreasonable about how the Stinney family has proceeded over the years, given all the facts and circumstances of this case. And I would just say one last time, you have before you in the record, whether you rule today or rule later, you have before you when things were really done in terms of who did the research and who did the findings. And we think it's clear. Novelizations in TV movies, whatever they're worth as entertainment, are worth nothing in the courtroom. And the only real thing that we see in the record is what Mr. Frierson did as of 2004. And that's when it started, when he first dug up some serious, not completely, but some serious evidence that makes a difference. So for those reasons, unless there are no further questions, we would ask the court to please grant the motion for quorum nobis and vacate the judgment of conviction in this case.
All right. Well, I don't want to prolong this proceeding anymore. We've obviously been going for almost 2 days now. We do have other matters to take up. I do want to give the state an opportunity, though, to brief for me quorum nobis. It was something that was proceeded on late, and I understood that because we did have a term of court, this was not a special term of court, this was just me being assigned here, that we wanted to go forward and have the hearing and present what we could. I think also the state needs an opportunity, if they would like to potentially rebut. You can sit down, Mr. McKenzie, until I'm done. That we will give the state the opportunity, if they would like, to rebut the forensic pathologist statement, Dr. Stevens, and also the forensic psychiatrist, if the state wishes to. Again, that is up for you to determine, Solicitor Finney. Additionally, I would leave the record open for any possible amicus briefs. Obviously, when this gets news media and coverage, other people become interested. It's how you have been able to garner new witnesses, or witnesses come forward. So we would leave it open for a brief opportunity. And again, I think that's important. We need to put a deadline. What kind of deadline, solicitor, would you like? I know it's,
I don't think that 10 days would, I don't think we couldn't accomplish what we need in 10 days, Your Honor.
okay. I will go ahead and give you 10 days as far as briefing is concerned as to the quorum nobis issue. If you do feel it necessary to engage, again, a forensic psychiatrist or a pathologist, I'll give you certainly an amount of time to do that with certainly some opportunity to cross-examine, and hopefully that can be done.
Your Honor, please, may I ask, are we now proceeding singly as the court ruled on the 29B?
Have you given up your Rule 29B motion, Mr. Shealy?
I would ask the court, since you're holding the record open, like you indicated, there's no reason to rule on that until you have your deadlines met.
Okay.
I would ask you, and I don't want to ping pong this back and forth, could we have 10 days to reply if we see fit? Since we're the moving party, we had to file, they have to respond, and normally one gets a reply, so
Certainly,
thank you.
certainly. Okay. And then again, if you need further time or anything you need, solicitor, you can certainly request it, and I'll consider it. All right? And for the rest of you that have come here, I want to thank you all for being here. I think one of the problems that originally this trial had was whether or not someone felt like they had their opportunity to fairly present the case in court. Whether or not it was or it wasn't, again, right now that's not for me to say, but rather I think everyone has had an opportunity to say their piece, say their feelings, and I appreciate that, and I want to commend certainly the lawyers on behalf of the Stinney family and the solicitor again for representing your parties diligently. And I want to thank everyone for being here and appreciate y'all. For those of you that are here for the afternoon session, we are going to start back up in about 15 or 20 minutes. We do have other matters to take up, ladies and gentlemen. So we will be at ease. My understanding is the deputies have been taken care of as far as lunch is concerned, and we can go ahead and go forward. Is that correct, gentlemen? Yes. All right. Well, thank you. In this matter, we will be adjourned. Thank you. Thank you. Sure.
I just want to bring to your attention, none of the bailiffs has had a noon meeting.
Okay, so they need to use.